Top story tonight, a woman has been arrested after a video pops up on social media showing her beating a 3-month-old puppy with a belt.
As KENS 5's Mike Jimenez explains, the video has upset thousands in the community who are now calling for justice.
The video is heart-wrenching to watch. And we have to warn you, some viewers may find the video disturbing. The video is so horrifying to watch that we're only going to show it to you once. In a video posted to Facebook, Havanna Miller is seen on the balcony of an apartment complex in the 12,000 block of Culebra, holding a 3-month-old poodle while whipping the puppy with the belt 17 times. In the video, you can hear Miller yelling at the puppy while the puppy cries. The puppy eventually breaks away and runs into a corner. 2 more strikes follow. The video was sent to Sally Arnold, a member of several dog groups, on Facebook, asking for help. Arnold posted it on Facebook Friday around noon. Arnold says when she saw the video, it broke her heart.
I just was bawling, and I don't understand how anybody could do that to a dog who can't defend itself.
Immediately, people saw the video and wanted to help. Renaya Rubio saw the video and went to Miller's apartment. She told Miller through her Ring doorbell camera that she witnessed her hitting the puppy and offered her $300 for the puppy, or she would call police and show them the video. Rubio says Miller agreed and said she did not want the police involved. Then Rubio says the price kept going up.
She's like, I got him for $1,000. Like, the least I can do is $750.
Rubio only had $500, so she began asking for donations. The video started going viral and people were donating more money. But then Rubio says Miller now wanted $1,000.
We never got the puppy. Another source had called the cops and apparently had sent them the video. And so that's when the cops and ACS, I guess, got involved.
San Antonio Animal Care Services got a warrant and around 6 p.m. Friday picked up the puppy. ACS says Miller was arrested Saturday and is facing a charge of animal cruelty, torture, a 3rd-degree felony punishable between 2 to 10 years in prison. From what started as cheers of sadness for Arnold turned into tears of joy after learning the puppy was now in the city's care.
I just want to make sure that she's not able to do this again.
A petition on change.org was started demanding the maximum sentence for Miller. At last check, more than 8,000 people had signed the petition. We did reach out to Miller, but have not heard back. Mike Jimenez, KENS 5.
The issue with this statute is very specifically in regards to it's the torture provisions of 42.092. And what I mean by the torture provisions is in 42.092B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. And that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just feels cause a dog unjustifiable pain and suffering without requiring any proof of bodily injury. Humans don't even get that level of protection. So there was an alleged video taken of an incident in which it's claimed that Miss Miller struck the dog 15 to 17 times. And then it's posted all over social media. And there's been death threats, gang rape threats, and everything under that. It's been on the news, Facebook. And so my concern is just that I don't know exactly how.
Yes, I'll be here the week from the 15th through, for the remaining of the year. But the 22nd, you all will need to confer with Ms. Ferguson because I know we have some capital murder cases and murder trials that are up. So if you all would confer with Ms. Ferguson and Norma, the date you give them a Monday date so that we can have the hearing with regards to the expert. So we'll do the expert hearing after we have docket on Monday. So we'll do it in the afternoon.
Okay.
And so if y'all can see when your expert will be available, we'll have that in the afternoon of whatever Monday and go from there. Could I have parties announced?
Lauren Espinoza for the state.
Jody Sawyers and Jared Hall for defendant Havanna Miller.
And are you Havanna Miller?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Ms. Miller, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with cruelty to non-livestock animal as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow that plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Do you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court would find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Miller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're a U.S. citizen, by entering into this plea, you will be deported, not allowed to re-enter the United States, and denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. So we were scheduled for a jury today. There was a jury in the hallway. The court released the jurors after the parties said that you all have reached an agreement and are asking the court to accept your agreement. Is that correct, state?
Yes, Your Honor.
Is that correct, defense?
Yes.
Right. So, Ms. Miller, there was a jury in the hallway waiting to come into court. You would have a chance to have the state call their witnesses once the jury was selected. Your attorney would have a chance to cross-examine those witnesses. Did you understand that? And are you giving up that right to a jury trial?
Yes.
All right. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, again, the state is asking that your punishment again be assessed at 10 years in the prison. There's a $2,000 fine. The state is going to be opposed to your application for deferred adjudication. So what that means is they're saying they do not want you to have deferred adjudication. They are in agreement to your being granted community supervision. Do you understand?
Yes.
So what that means, if the court were to deny your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement. Do you understand? Did you understand that to be the plea? Defense?
That is correct.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
So that's like, I apologize, maybe I missed that in the paragraph, Your Honor. But my understanding, what I explained to her, was that any of motions that we filed and had heard, the motion to quash, the evidentiary motions and stuff like that, those are not being waived because we had a ruling, we haven't waived those. Okay. But those have not been waived. Right. So
All right, so this is what I'm saying. So this is what I need everybody to do. Listen to me closely. Did you sign in both places here the waiver of appeal paragraph?
yes.
By signing that, this is what it means. You're waiving your right to appeal. The only thing that can be appealed would be any pretrial motions that have been filed, that have been heard by the court and ruled upon. Do you understand?
I do.
All right. Have there been any such motions?
Yes.
All right. Now, outside the agreement, the state is requesting that your community supervision be for a term of 10 years. They're asking that there be a TAP evaluation, 150 hours of community service restitution, the MRT, anger management, no pets during probation, field visits, 180-day jail sanction. Do you understand? Those are recommendations from the state, and the court does not have to follow those recommendations. Do you understand?
Yeah.
So those recommendations are not a part of.
Instead of rolling the dice on a jury trial, Havanna Miller gives up her rights and accepts a plea deal. Now, here's where it gets interesting. The prosecution flat out rejects deferred adjudication, meaning Miller won't get the benefit of having this wiped clean later. Instead, they want strict probation with jail time hanging over her head, 10 years on supervision, thousands in fines, and a ban on owning pets. That's no small punishment. What do you think, viewers? Did Miller make the smart move, or should she have fought it out with a jury?
Of your plea bargain agreement, they're just recommendations. So when you're looking at this plea bargain page, everything above this line, that's your plea bargain agreement. Everything below where it says waiver of appeal paragraph, those are just recommendations.
Okay.
So if the court were to follow your agreement and grant your application for probation, or either grant your application for deferred adjudication, the court is the only person that can give your conditions. So for example, the state is requesting 10 years probation. That's how long they're asking that your probation be for, 10 years. If I don't follow that, if I were to sentence you to 9 years probation, that's not a violation of your condition, because you all are not allowed to reach an agreement for that. They're saying they want 150 hours of community service restitution. If I were to give you 200 hours or 300 hours, that's not a part of your plea bargain agreement, so that's not a violation of the agreement that you've reached. They want the MRT course. If I don't give you an MRT course, that's not a violation of your plea bargain agreement, because that's not a part of your plea bargain agreement. All of these conditions that are below this line, those are recommendations. Do you understand?
Yes.
All right. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objections.
All right. Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
By entering into this plea bargain agreement, the state is not going to call any witnesses. Through these stipulations, the state is going to present their evidence in the form of police reports, videos, and witnesses' statements. Do you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. If you would like for a PSI and a TAP evaluation, that's 12 weeks. Or if you would like to just reset it and bring witnesses, we can have it brought sooner.
I believe the 12 weeks, if we can do that, to have a full assessment for the court. And then, Your Honor, in regards to, we had already preserved our rights as the constitutionality challenge on a motion to quash on its face. But at this point, I would also assert to the judge constitutionally as applied. And now that we have the evidence in and the facts, I would like leave of the court to at least file that motion as applied and get a ruling and have a ruling that day.
Oh, that motion.
Well, so on a motion to quash, you can't do unconstitutional as applied. You have to wait until the judge.
No, I mean,
or the court.
what motion?
A motion objecting to the constitutionality as applied. It's timely after there's been an adjudication of guilt. So I just want leave of the court to file that motion and get a ruling on it.
Oh, everybody can file whatever they want to file, and I'll hear it.
Fair. Because I know right now we're talking about appeal, and I think you'll wait until after the sentencing to do the trial rights certification of appeal. Is that correct? So I just wanted to kind of give the court heads up as to the constitutionality as applied, that we're trying, or our intention is to preserve that. Okay. Thank you so much.
Thank you.
What
right. Date? All right, Ms. Abrams, is there any way to have this expedited before then?
Yes, sir. And I have at least 4 weeks.
All right. What date? In 4 weeks?
Are you asking me?
Yes. What date?
October 28th.
All right, we'll be back on October 28th for sentencing.
Thank you, Your Honor.
All right, thank you. Once you sign the reset form, you're excused and speak with probation, okay? Thank you.
And with that, the court locks in the next chapter, sentencing set for October 28th. Havanna Miller stands convicted under a plea, but the defense hasn't given up. They're still angling to challenge the very constitutionality of the statute itself. That means this case isn't just about Miller. It could have ripple effects on how Texas defines and prosecutes animal cruelty going forward. For now, Miller walks out under probation's shadow, her fate hanging in the balance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
A San Antonio woman has taken a plea deal in a felony animal cruelty case. You may remember this story. It involved a viral video which showed Havanna Miller repeatedly hitting her small puppy earlier this year. Well, in court today, Miller pleaded no contest to the felony charges. Miller is set to be sentenced on October 28th. She faces between 2 to 10 years in prison and up to a $10,000 fine. The puppy was eventually transferred from ACS custody to an out-of-state rescue group and has since been adopted.